Hello, everybody. Welcome back at the conference. And at the last session of today, we are going to discuss labour market cartels in Africa, why the perceived regulatory disinterest. Again, we have a great panel of experts that's going to help us with these questions. Lesley Morphet, a partner at the competition law practice at Fasken in South Africa. Dr. Mahmoud Momtaz, who is the chairperson of the Egypt Competition Authority and the COMESA Competition Commissioner. Mr. Pedro Gouveia Melo, partner at Morais Leitão, operating from Portugal and specialising on the Portuguese-speaking authorities in Africa, Mozambique, Angola, Cape Verde. Mr. Steve Cernak, partner at Bona Law, and in the Detroit office and chair of the American Bar Association of the Antitrust Law section, and Talita Laubscher, partner in the employment practice of Bowmans. Welcome and thank you to all our speakers for joining us on this important discussion. We are going to discuss the issue of labour market cartels, and the traditional notion of a labour market cartel is basically two firms agreeing not to poach each other's employees, or, for example, firms agreeing with each other to offer very particular salaries or other benefits to their employees. And a labour cartel basically constitutes a supply-side cartel. And because inputs are not competed for, four things happen. First, your employment costs remain fixed, so that's the first anti-competitive effect. Secondly, the employer becomes a very powerful buyer, so that creates an imbalance in negotiation power. And indeed, the US Worker Guidelines references monopsony power, so that is a real anti-competitive effect. Firms do not compete for talent or certain talent combinations, and that again impacts innovation and knowledge sharing in firms. And that also reflects a very important observation in the latest US guidelines that labour mobility in and of itself can influence competition in a product market or in a service market. And then the fourth effect is that employees are less likely to earn better salaries and less able to grow in that regard and to contribute productively because they are basically forced to move into other supply chains and not really able to apply their skills where they obtained their experience. So as you can see, a labour market cartel is actually quite serious, even to some extent more serious than a demand-side cartel. And they can cause multifaceted problems from a competition perspective. Interesting to our knowledge, no African competition authority appears to prioritize the prosecution of labour market cartels. I'm mindful that the Mozambique Competition Authority at one point had it on their website that is something that is anti-competitive, but to my knowledge, they haven't pursued any of those cases. And this void in African competition enforcement is despite an almost universal orientation in Africa towards the protection of public interest. And compare this to the US and Europe, where the prosecution of labour market cartels are quite strong. And this is not a recent phenomenon. This is something that we picked up at least 3 years ago already, that there's this particular divide between the way that Africa does it, where the real problem actually persists, and then the more developed nations. Dr. Momtaz asked that we can address these questions first. Unfortunately, he has a commitment tonight. So, Dr. Momtaz, I'm going to start with you. Would you say that my summary regarding Africa's hesitancy is correct? Or have you seen certain green sprouts in this area? If you can share your views from your perspective, COMESA, the Arab world, is this a fair thing to say?
No, thank you so much for having me. It's a pleasure. To go straight to the question, I mean, it's what you analyze in terms of facts. There are cases, I do myself also do not recall cases that really focus on this matter, but would that be a trend of African competition agencies tend to see that this is not a priority? This is something that I might be a little bit disagreeing with, because I think still the African countries, especially I would say one country such Egypt, we have a huge population. Nigeria, the same thing. Other countries would be the same. So I think the matter of employment is something that's very important, and I think this is embedded in a different jurisdiction. I mean, even in COMESA, as you've mentioned, public interest is part of the analysis. So the idea of employment itself as part of the analysis, I think it's also something that it's being focused on, and I think there is a couple of merger cases that have been looked into by COMESA and looked into this matter specifically when it came up from the member states as a concern in certain transactions. So from that being said, I mean, this might be still be a priority, and the fact that there was no cases does not mean that this is not a priority. Again, the jurisdiction you've mentioned been there, established for quite a number of years. Compliance within these markets might be at a much higher stage than other markets, and that's why maybe it might be this is the case. But I think no competition agency would see a potential violation in these type of markets, and it would ignore it. That's for a fact, because again, part of the analysis and part of the vision. I mean, if we looked in most of the strategies that are published by competition agencies within the African continent, you can see that they focus on not only consumer welfare but rather total welfare. And that's something that gives us, in essence, as you've mentioned, that looks into both sides, what's happening on the supply side and what's happening on the demand side.
Yes.
So that's in brief what I have to say on that regard.
I see. And would you find in mergers that the issue of labor cartels are being highlighted, or is it just the issue in terms of labor from a retrenchment perspective?
Yes, the latter. I mean, this is where would have been happening, but I think it's still something that we I think it's might be given a more type of analysis, especially in enforcement, because, for example, giving you in COMESA, the types of enforcement was not as much as the amount of merger transaction that the COMESA is seeing, but there is a change in the direction within the COMESA Competition Commissioner, for example, that now it's begin to focus more on enforcement, especially with the change in management with new CEO. I think this gives us a little bit of essence of how things are going. Even in Egypt, if I would talk about ourselves, also within our compliance toolkit, it's still there. So we do look into it, and as long as we can find a case, definitely we were going to be prosecuting on that regard.
I see. Are you aware of any guidelines, for example, that are being issued by competition authorities to indicate publicly that it is a priority? And what would it take from a priority perspective to get to that point?
I don't think that most of the things I would see in African countries and even in Egypt, I mean, don't focus on the violation per se, but we rather focus on the sector. So in Egypt, the case I would be telling you that the prioritization is in the pharmaceutical sector, in the food sector, in the education sector. These are the priorities. If within these priorities, if I could find a cartel, definitely. As mentioned in the Trinco case, it's the supreme evil of antitrust. Then I would go against it one by one. If it's a price-fixing cartel, if it's a labor cartel, we can name it. So that's how we can see it. So I don't think there is a strategy per se that focuses on the violation, but rather on sectors. That's what I have to say on that.
That's fascinating. Thank you, Dr. Momtaz. We're not going to keep you any longer. We are mindful that you must run. So thank you so much for making time for us in any event. We really appreciate it, and thank you for your contributions.
And I apologize for this appointment that I had to go.
Yeah,
so
not
much.
at all. All the best. Bye-bye, doctor. Lesley, I'm going to ask from your side as well, the observation that there are some hesitancy regarding the enforcement of labor cartels specifically. What is your observation in relation to the English-speaking world? Is that something that we are neglecting, or not necessarily?
I wouldn't say it's something that we're neglecting, as there are lots of other topics that our authorities can focus on in the meantime. And certainly, where South Africa is concerned, I think our competition authorities are very conscious of the need to look after workers. If you look at our act, I mean, even in the preamble, it talks about the importance of employment. There's the object and purpose of the act. It also refers to employees. So it's not that we aren't interested in employees. And as I think has been noted around the world, South Africa leads the way in dealing with public interest issues in mergers, including in relation to employees. And in fact, that used to be a focus until it was expanded to other aspects a few years ago. So I don't think it's that we neglect employees. And I question whether there is a need to focus on this in South Africa if one considers collective bargaining is specifically excluded from the ambit of the Act. And I think we've got well, Talita, I'm sure, knows more than I do about the employment environment. But my perception certainly is that trade unions are quite active and strong in protecting their members. So I don't think that we have the same imbalance of power, if one can call it that, that seems to have been the case. Steve will know better than I do, but I think in America it's a very different picture. And so maybe there was a need for this focus in America, where I'm not sure that we need it in South Africa, and it's not entirely dissimilar in the rest of Africa, I would think. So it might be that the reason why there isn't this focus is because employees aren't as disadvantaged, perhaps, as in other markets.
And Steve, you've been put on the spot by Lesley. That's not me. It's Lesley. Would you like to share your thoughts in relation to the prevalence of labor cartels specifically, and what led to the issuing of two sets of US guidelines, one in 2016 and now a recent one, 2025? Can you provide us with a little bit of context as to what gave rise to those two guidelines?
Sure. So yes, in 2016, so this would be near the end of the Obama administration, we got this guidance for human resource professionals, HR professionals, coming out of our Federal Trade Commission and the Department of Justice Antitrust Division. And for the most part, many practitioners like myself found it kind of odd because, of course, those kinds of what you call labor cartels, wage fixing or no poach agreements, employers agreeing not to hire each other's employees. Of course, that's going to be subject to the antitrust laws. If it's naked agreements like that, it's going to be automatically illegal. If it's connected to something else, it will be subject to our rule of reason. Why do we need, this kind of guidance? What we got from the first Trump administration a few months later, they came into office and said, wow, yeah, there are an awful lot of investigations going on because there's an awful lot of bad behavior going on. And we'll talk a little bit later, I think, about some of the results of that investigation. And I'll also say that when I went out and talked to some of these HR professionals, their reaction was, what the antitrust laws applies to us? I thought that just applied to the sales and marketing people.
Exactly.
So there was a real I think need for guidance because the people who were doing this kind of hiring and making these sorts of labor decisions did not understand that the antitrust laws applied to them.
I see.
So now the guidance in 2016, again, most of it was, I would say, a restatement of what we already knew, except for expanding the criminal jurisdiction to naked wage fixing or naked no-poach agreements. So that was something new that certainly got everybody's attention. Oh, and again, we'll get to some of the results of those criminal cases in a little bit.
Yes.
But if you fast forward to 2025, what you get is, I would say the most important thing is that it's pretty much the same. That is, this kind of guidance was followed in the first Trump administration and the Biden administration, and in the 2025 antitrust guidelines for business activities affecting workers, so the title changed. But most of the guidance is exactly the same. A couple of different permutations here. First, they expanded some of the non-obvious, at least to antitrust lawyers, non-obvious things that they're going to be interested in, like perhaps sharing too much sensitive wage information, in some benchmarking activities, or overly broad non-disclosure agreements, or non-compete agreements, or a shared use of algorithms in order to determine or to suggest what the wage should be. All of those will at least be issues to be investigated, not necessarily illegal, but issues to be investigated. And then I think that this Trump 2 administration has made clear that, unlike the Biden administration, they're looking to be they're looking to go after what they perceive to be antitrust violations. They are not looking to be ex-ante regulators. So I do not think you will see the kind of attempts that the Biden administration made to make nearly all non-compete agreements automatically illegal. Instead, it will be a case-by-case basis in all of these activities affecting labor. So, to Lesley's point, it was a surprise to many of us, but it does appear that there were an awful lot of bad activities going on here in the United States regarding labor, and so the enforcement authorities took off after them.
That's a good point. And I sometimes wonder whether we think that there's compliance. In the beginning years, I remember the story is often told that we always thought in South Africa that we don't have cartels until leniency was promoted, and then the applications came in, and then we realized, wait, everyone is in a cartel. Pedro, can you give us some indication from Europe's side as to the lay of the land? What is the level of prosecution of labor cartels? And then also, have there been any guidelines that have been issued in the EU?
Sure. So first, let me also thank you, Odie, and Betwiti for the lovely invitation, and it's a pleasure to be here.
Absolutely.
So no poach agreements and no solicitation agreements are a recent phenomenon in Europe. It has the enforcement practice has evolved in recent years. The most important cases are very recent ones. The European Commission just adopted its first significant decision imposing large fines for no poach agreements 2 weeks ago. So on June the 2nd, the French authority adopted a similar decision last week, also imposing a 30 million euro fines. There's an important case concerning Portuguese football clubs, which were fined actually by the Portuguese Competition Authority, and the case is now pending before the European Court of Justice in Luxembourg. The court will rule on whether these kinds of no poach agreements, and that case concerns specifically an agreement entered in the context of the COVID pandemic, so in very specific circumstances, and whether these kinds of agreements are what we call in Europe and also in Angola and Mozambique, restrictions by object. So prima facie restrictions, which are not exactly, but close to per se infractions under US law. And so yes, the enforcement is very lively. These are just 3 examples. There are also guidelines in place. The European Commission, so the European Competition Authority, has issued guidelines last year. Very well, basically saying that generally speaking, no poach agreements are restrictions by object, and that justification under or exemption under efficiency reasons is very difficult in practice. There are a number of other national competition authorities also having issued guidelines and reports. Nowadays, the UK, Great Britain is outside the EU, but the CMA, the Competition and Markets Authority in the UK, is also very active, and it has also a 2023 document on guidelines with also recent fines. So recent phenomenon, but very active enforcement in Europe.
Yes, thanks very much, Pedro. Everybody's very busy with this. And Talita, if we look at labor cartels, does South African labor law prohibit labor cartels, and which labor cartels are generally lawful? If we can get them out of the way, then we can focus on the bad stuff.
Yeah, thank you very much, Uri, and also for me it is a privilege to be here. Thank you very much for the kind invitation. So if we are talking about cartels, we are talking about perhaps wage fixing and no poaching agreements. And as I understand it, that's between different entities, different employers, who now agree we will not take your employees. What labor law is about is the regulation of the relationship between the employer and the employee, and to some extent the employer and trade unions. So Maria von Trapp in The Sound of Music would say, let's start at the very beginning. That's a very good place to start. And that is, of course, Section 23 of our Constitution. And that section says everyone has the right to fair labor practices, not just employees, employers as well. So what we see in employment law is a careful balancing of rights. On the one hand, the employer's rights, and on the other hand, the employee's rights. And that is really what guides the employment law in South Africa. So no, there isn't anything in employment legislation that will talk about this relationship between 2 entities in relation to poaching and so on. But it doesn't mean that labor law is blind to mobility questions and the protection of rights of employers. So, for example, where an employee uses the employer's confidential information and trade secrets to set up a business in competition with that employer, that would be regarded as an act of misconduct for which you can get fired. And just as that happens in the employment relationship, our law recognizes that the employer can protect its proprietary interests by way of a non-compete. So it is not agreeing with another employer that you will not take this employee. We're agreeing with this employee, you will not go to another employer, well, a competing employer, and you will not poach our people. And that, again, is not just a blanket right, because our law recognizes that no right is absolute. So there's always a careful balancing of rights. So there are guardrails in relation to that situation where you have an employer agreeing with an employee not to join a competitor, which we typically call a restraint of trade. And very importantly, it must be an agreement in writing. And there must be a proprietary interest worthy of protection. So that would be things like customer connections and trade secrets and intellectual property, especially in those areas where intellectual property is created. Also, it needs to be reasonable in respect of the area in which it applies, the time period for which it applies. So those guardrails are important, but when they are tested, then the onus is on the employee actually to show that it is unreasonable, because that is another very important point in our law, and perhaps a perspective that our courts say contracts mean something. Contracts need to be adhered to. So if you want to avoid the consequence of a contract, you need to prove that it is unreasonable. It is not for the employer to come and prove that it's reasonable.
Exactly.
Especially where we've agreed it in writing. So yeah, that is from the perspective of the employee joining a competitor after employment, and there is then a restriction on that employee not to go and work for a competitor and use all of this information and customer connections, for the benefit of that employer. So what we've also spoken about a bit is wage fixing. So in many jurisdictions, there's a minimum wage, and in South Africa as well. And that is around 30 Rand an hour. There are various sectoral determinations that have lists and lists and lists of wages in respect of specific jobs. It's normally for the lower level employees, and those are either promulgated by the state or they are concluded in bargaining councils through, as Lesley mentioned, the process of collective bargaining.
Correct.
Or in other collective bargaining agreements. And they set a minimum. So it is part of the balancing of rights, so that there isn't a race to the bottom. So, and that employees are exploited through naked wage offers from employers.
Yeah.
Because they can't find efficiencies in other areas.
Yeah.
So it puts a minimum. It doesn't prohibit you from paying more, but Lesley will argue that then why would you pay more? And isn't that then actually a way of fixing wages? But I think also the balance there is that where these are promulgated or agreed in bargaining councils, we are not talking about the senior levels of employment. We are talking about the vulnerable.
Yes.
And also in my experience, it's very unlikely that you will restrain the low level workers. They are free to move. So if I do think of a case where perhaps there are two entities where they agree we are not going to take each other's employee, then it is normally in the context of a labor broker or a temporary employment service that is providing people to a client. And in that agreement, you might find you will not offer employment to this individual within a period of 12 months. Or in some cases, which is perhaps a little bit more clever, is in the event that you do want to offer them, you will pay us a placement fee.
Yeah.
So that is what I've come across also in secondment arrangements, where an entity sends an individual to perform work for another entity. Those kinds of arrangements can occur, but yeah, outside of that, labor law doesn't
Yeah.
really regulate the what the two entities can do as between each other.
That's right. And it also sounds as if there would be good business reason to restrain those employees from not just walking over to the other side, or let's say the companies from poaching them. It's quasi non-poaching agreements, it sounds like. Thanks, Talita. A couple of months ago, I had a very interesting discussion with a colleague of mine, and she said that she was quite surprised to see how prevalent restraints at a very low level is. For example, shelf packers, and yeah, she's in the competition space. So sometimes, yeah, as I mentioned before, I wonder to which extent these lower wage employees are being exploited, and we are not really aware of that. Lesley, have you come across that type of restraints at low wage level in your due diligences, or is that also something that you are not aware of?
I must say I was intrigued to hear you talking about this, because I haven't come across it, and it does puzzle me, as Talita mentioned.
Yeah.
It's not really common amongst lower levels of employees.
Yeah.
But I would think it would be, if it is prevalent, I would think it wouldn't pass the reasonableness of a restraint test. So it would be problematic, but I haven't come across it, no.
Yes, I see. And Lesley, let's say you come across it. Is this something that you would encourage an employee to apply for leniency? Or is the institutional development of prosecuting labor cartels not yet mature enough to go that route?
Oh, that's a good question. I don't know whether it's not mature enough or not being, or what the reason for this would be, but I don't think I would ever be complacent about thinking it won't be proceeded against. It's always possible that the Competition Commission might come across something on their own and conclude that there's a problem. So if I were to come across something that I thought would be problematic, I would certainly alert the client to it and explain in what context it is problematic. And yes, I suppose the technique of leniency, the advantages are such that one would obviously tell the client, this is a distinct possibility if you want to avoid the fine yourself, because the first through the door in South Africa does not expose itself to a fine, although they are not protected from other damages cases. So I don't think it's something that I wouldn't tell them to do, but obviously they weigh it up and they come to their own decisions at the end, having seen the pros and cons.
Yeah.
But I would never take that risk, I don't think.
Yes. And if we consider what Dr. Momtaz has said regarding labor cartels not necessarily being a non-priority in Africa, the authorities have just not come across it. Would you agree with that, Lesley? Or do you think there is room for something like a particular guideline, making the industry aware of that, to beef up enforcement of that? Or do you also feel it is implicit, so just leave it there?
I think it's implicit, but to the extent that authorities did conclude that they wanted to focus on attention on this area, guidelines would certainly be a possibility, or awareness campaigns or something of the sort. But one also has to be careful, because even if it looks like a naked restraint, it may be that there is some reason, some characterization aspect that would mean it doesn't fall actually to be it shouldn't be prosecuted. And certainly I must say, where South Africa is concerned, I do feel that we're wanting to attract investment. We're wanting employers to hire more people. because we have a very high unemployment rate. I wouldn't go take any route that would actually start hammering employers more than they perhaps feel they're hammered at the moment.
Steve, can you share with us some of the cartel cases that the US have looked at up to date? Well, to date.
Yes, and let me, I guess, first remind everyone on the call that here in the United States, we have several ways to enforce the antitrust laws.
Yeah.
As I said in my first response, the federal agencies, the Federal Trade Commission and the Department of Justice Antitrust Division, issued this guidance and said back in 2016 and said that they might prosecute some of these criminally. That was an expansion, so that was new. Before, criminal prosecutions were only limited to product price fixing.
Exactly. Yeah.
So criminal is one way. Civil cases can be brought again by the federal agencies, but they can also be brought by the state attorneys general. So we have 50 states plus some territories, each one of which has the state government has a top attorney. They can again bring civil cases to enforce the federal law or their own state antitrust laws, because all 50 states have antitrust laws which are very similar to the federal antitrust laws. And then, of course, here in the United States, we have private actions for treble damages. So lawyers on behalf of a victim, or in some cases a class of victims, can bring antitrust suits for treble damages. And so really all of these areas have been used here in labor activities. So first, the first of three categories that I would talk about is the criminal ones. So that was new in 2016. We got three cases that came in about 2019 or so. They finally actually got to trial. And interestingly, the government lost all three of them. Now, the judges did allow the criminal complaint to go forward, so did accept that these kinds of activities could be prosecuted criminally. And the government did win on some non-antitrust claims, such as obstruction of the investigation and the like. But when it came to the actual jury verdict for whether there was wage fixing in all three of them, the jury found that there was no agreement. Basically, the facts found that the jury found that the facts showed that there was an attempt at an agreement. There were plenty of emails saying, "Hey, we think the wage ought to be $10 an hour or whatever," but there was no that attempt at an agreement was unsuccessful. There was plenty of evidence that wages were actually higher. The average wage was higher. There are plenty of exceptions to that alleged agreement. Now, more recently here, just a couple of months ago, there was a fourth criminal trial, again on wage fixing, and here the government finally won. And so in the U.S. v. Lopez case, we've got our first criminal conviction for wage fixing. So now we've got that. Second category that I would talk about would be private civil suits, and a number of these have been pursued in the form of class actions. And some of them, including some of the largest ones, were pursued before the 2016 guidance and were pursued against not just the lowest wage workers or employers of the lowest wage workers. That is, some of these cases were for employees who worked in animation or cartoons, or worked on railroads, or worked in technologies. Exactly. So there were several that affected cases that went after fairly large companies, large employers, and well-known companies, and were alleging that there was some sort of either no poach or wage fixing of some kind for these employees. I would say all of them were successful all of these cases were successful. Not necessarily that they got a verdict, at the end of a trial, but instead that they settled out, and the alleged victims did receive some sort of compensation, and the employers, changed their practices in some way.
Yeah.
There were also some of those in smaller geographic areas, especially involving healthcare workers, nurses, and home healthcare nurses. The third one that third category that I'd like to highlight gets to something that both Lesley and Talita have talked about, low wage workers. We've also seen a number of cases involving franchisors and franchisees, especially in fast food franchisees. So think about McDonald's, but also a lot of other franchisors, maybe not quite as well known globally. The franchisors have an agreement with the franchisee, and they provide lots of material to the franchisee, including, as it turns out, some standard employment agreements that their franchisees either must use or are allowed to use. So the franchisees do not need to come up with these themselves.
Yeah.
Many of these standard employment agreements included either a non-compete, so the employee said, I will not go work for a competitor of McDonald's, or some sort of no poach agreement. The franchisee agreed with the franchisor, McDonald's, that the franchisee would not poach employees from other McDonald's franchisees.
Yeah.
This drew the attention of a couple of state attorneys general, especially out in Washington state, so the state of Washington, not Washington, D.C.
Yeah.
But also a number of private class actions. And just as the discussion we talked about, it was very difficult to justify why you couldn't allow somebody who was, merely cooking a hamburger or merely putting, French fries in a bag, why you couldn't allow that low wage person to move down the street, to the other McDonald's franchise. And again, I would say all of those lawsuits were successful, even if they didn't get to an actual trial, because again, the practices changed. The franchisors either stopped providing the standard employment agreements, or at least modified those standard employment agreements, and the franchisees changed their practices, and all of the employees or potential employees received, some sort of compensation. So again, lots of different ways for lots of different kinds of employees. But there are many different ways that the antitrust laws can be used to alleviate these kinds of concerns. And I think we've used all of them here in the last several years.
So thank you very much, Steve. That's very interesting. If we look at the US guidelines, the difference between the 2016 version and the 2025 version, do I understand correctly that the latest version places a special emphasis on labor mobility as well, in addition to the pure cartel type of arrangements?
I do. Yes, I do think that that's probably right. I would describe it as making it more explicit. I think it was implicit in 2016, but the 2016 guidelines really were aimed at wage fixing, no poach agreements, things that seemed obvious, and so obvious that we're going to prosecute them criminally. That's what the guidance was concerned about. Here in 2025, those are still, contrary to the antitrust laws, but now they have talked more about we want to make sure that other methods, other activities are not used to slow down labor mobility. We want to allow employees or potential employees to try to find their best employment options that allows them to flourish in whatever way they find important. So we're talking about making sure that the employers do not share too much wage information. If they share too much sensitive wage information, even though they might not have shaken hands on a wage price fixing agreement, that can have the effect of reducing the wages and reducing the desire to move somewhere else to get a different job. It's just going to be the same wage anyway. And I think other less obvious ways of violating the antitrust laws, of reducing labor mobility, of reducing labor costs, all of those are now made much more explicit in the 2025 guidelines.
I see. Because something like, for example, making sure that if you sponsored an employee to go and get some training, that you must sure that you do not restrain him too much in terms of time that he has to work back for you. And that is quite interesting, that the problem is of such nature and extent that is the type of thing that you have to include in an agreement, well, in the guidelines.
Well, and one of the things that was made explicit in 2025 guidelines was that, okay, maybe you've trained the employee, you've spent some amount of money to train the employee, and so if they leave, you'd like to recoup that loss in some way. And theoretically, I mean, Talita can comment on this. Theoretically, that sounds appropriate. But what the government was finding was that sometimes those costs that were being recouped were very, very large, perhaps artificially large, perhaps not really the real cost. And so, yes, technically the employee had the freedom to move, but in order to move, he or she had to pay hundreds of thousands of dollars in alleged training costs that the employer needed to recoup. That's the sort of issue that the 2025 guidelines is taking on. Again, not making it automatically illegal, not per se, not by object in any way, but more a rule of reason. But the guidelines brought to the attention of all the employers that if you think this is the way to get away around this, you have to think again.
Yes, that's interesting. Pedro, from your perspective and from an EU perspective, do you also see this emphasis on labor mobility as Steve described, or is the emphasis still more on cartels?
Well, the emphasis is on both. The enforcement has been on more traditional cartel-like behavior. So wage fixing and traditional no poach, but there's definitely scrutiny over any other legitimate agreements that may contain clauses with anti-competitive effects or even object. Of course, the difference between by object and by effect sometimes is difficult to establish in practice. For instance, the recent French case of last week, which resulted in these large fines, also included in the initial investigation a number of non-solicitation clauses in partnership agreements. So in otherwise vertical agreements that are usually legitimate or have legitimate purposes, and in the competition authority, l'autorité de la concurrence, and the decision has not yet made public. It's still undergoing confidentiality treatments. But in the press release that the authority published, the authority stressed that that part of the investigation was dropped because the authority concluded that in view of their purpose, legitimate, of the limited scope in terms of employees covered and the limited duration, that those clauses in partnership agreements were not illegal by object, and so and for that reason the authority chose not to pursue the investigation concerning those. That's very useful because that confirms that these kinds of clauses, if they have a legitimate purpose, and also if they are part of a legitimate and otherwise legitimate agreement, and are drafted in careful ways, they will be protected from the prohibition of by object agreements.
I see. Thank you, Pedro. And Talita, how would a labour court deal with the issue of labour mobility? How wise is it to encourage worker mobility to promote competition where it is in conflict with an employer's own interest? And how would a labour court deal with that?
Yeah, the Labour Court would look at labour law. So the Labour Court would weigh up the rights of the employer and the employee. And yeah, you know, no right is absolute. So yeah, you know, it's always that question, is it reasonable in these circumstances? What's being protected? And yeah, that example that Steve gave about the training, you know, we had a case where the client was a technology company and at the forefront of developing all kinds of mobile technology. And they send employees to Sweden to get training on this technology from South Africa. You know, so it is a 3-week, very intensive training program. And those employees are then expected to come back and you know, use it here in South Africa and rather not, you know, go and tell the competitor about all of that new technology immediately afterwards. And the amounts there that goes into that kind of training are genuinely high. You know, we interrogated that question specifically because we agree, you know, you cannot just make up a number and then think you can have a work back agreement and employees, you know, must pay back if they want to leave soon after. But yeah, you know, those kinds of things a court would look at. It would look at the evidence. It is data-based. It is not just, you know, we don't want to lose this person or, you know, that kind of thing. It is a balancing of rights. So that is how a court would approach it. The same applies to maternity leave. You know, in South Africa, maternity leave is unpaid. But many employers use paid maternity leave as a retention and an attraction principle. And again, you know, you sign, yes, I'll work for 6 months after I come back from maternity leave, or I will pay back what it cost you to pay me during my maternity leave. And that seems fair. So it's also not absolute prohibition, you can never leave. That cannot happen. It's always time bound. So it is a weighing up of interest, as I mentioned. So yeah, whether, you know, wisdom comes into it, I'm not sure, but at least we know that there is a balancing of rights.
Yes, thanks, Talita. Steve, if South Africa would like to pursue labour market cartels more aggressively, not just South Africa, the whole of Africa, first of all, is that something that you would think must be made explicit in the form like the US did it? In other words, to issue guidelines? So in other words, is it necessary? And then if so, in which format and in which instruments, how must Africa take this forward if it is something that we have to take forward?
Yes. So if you assume that it is something that an African nation should take forward, I would suggest going the route that the US agencies went. And that is issue guidance, and that could be, you know, guidance, here's what to do, here's what not to do, or here's what we're looking for, here's what we think is happening, here's what's bad, but make it explicit, make sure that everybody understands this is now a more of a priority than perhaps practitioners or clients had thought it was, and make sure that that is explicit and publicly known. And then I would suggest that the enforcement agencies should focus on the most egregious cases. That is, let's call it naked wage fixing or naked no poach agreements. Because I agree with Talita, Lesley, Pedro, all of whom have said there are plenty of times, plenty of situations when the restrictions that are put on the mobility of labor, or the restrictions that the information exchanged about wages could be pro-competitive, or at least not anti-competitive, could be explained in some way. But what we found in the United States is there were plenty of situations that are not gray areas. This is much more black and white, and this was clear that these competing employers, who also in many cases happen to compete on their product side as well, were talking to one another and saying, let's make sure we agree that the wages for our employees are X, or why did you hire the person who used to work for me? Don't do that ever again. Okay, I agree. I will never do that ever again. You see a lot of that. Those are the kinds of cases that I would go after initially, because I think those are the obvious ones, and I think that are obviously anti-competitive, and I think those are the easier ones to prove. It would be even better if all of those cases were for low-wage workers. I think because I think it would be more difficult to tell the kind of training story that that Talita just told. If you can do that in a couple of cases after making it explicit, I think you'll get the attention of employers. And I think to the extent that there is a problem, which we've assumed there is here, I think that would go a long way to alleviating.
I see. Thank you, Steve. Pedro, do you have any suggestions for Africa in this regard? Do you think this is something that we should prioritize, being mindful of the risk that if we don't know what we don't know, maybe our situation is even worse than in the US. What would you suggest for Africa?
So I would start with Steve's suggestions. They are so that's those are exactly the starting points. Clear advice, a clear and straightforward and plainly written advice for companies. So for instance, the European Commission often drafts, and those are, as the US agencies do, very complex or very complete sets of guidelines that are mostly addressed to us, to practitioners. These kinds of for these practices or these practices or this attention awareness raising exercise, best practice guidelines, very graphic, very short types of documents are more useful because they are addressed at company executives, at HR people that are not necessarily trained on antitrust law. So that would definitely be a good idea, even if the rules the rules don't have to change, because the prohibition of anti-competitive agreements is there on the law. As the Mozambican authority says in its overview on its website, for which is addressed at company, actually it includes the prohibition of no poach agreements. So that's a good start. And there are a number of authorities, or actually both competition authorities in Angola and Mozambique have already prepared a number of these very short best practice guidelines of the kind that would be useful here. I would also say that, of course, the priority should be straightforward illegal behavior. So clear, that should definitely be the priority. Maybe from what we have seen in other jurisdictions, business associations are frequently a hub of these kinds of discussions, and so they could also be a focus of not necessarily enforcement, but of attention, of raising it awareness. Exactly. And in some cases, it's like in the football case, and there are other cases that we are aware of, which are pending and which involved some kind of a formal or informal association. And in those kinds of cases are straightforward restrictions and could be pursued by an authority in a clear manner. And my third point would be leniency regimes. So that many jurisdictions in Africa have leniency regimes, both in Angola and Mozambique have them. But in many jurisdictions, they're either not fully operational or they're not used in practice. Of course, South Africa is a case of a jurisdiction where leniency is enforced, and that's a very positive sign. For instance, in Mozambique, there's both in Mozambique and in Angola, you have specific rules for leniency, but for a number of reasons they're not used. Regimes should be attractive, should be clear, should be predictable. So all these characteristics are important for companies to go to the authority and report questionable behavior. And so a way to enforce more competition law in these areas would be also to improve the leniency instrument in the jurisdictions where it's still not used effectively.
That's a good point. Thank you very much, Pedro. Lesley, would you think that labor cartels should be a topic for a market inquiry in order for the Commission to determine what is the lay of the land, or would you think that's overkill?
I think that might be overkill and also overstretch on the part of the Commission, perhaps, because they are very expensive and resource-consuming and time-consuming, I think, but also for the companies that are facing those inquiries. I think this would be quite a large topic to focus on. I think advocacy is the better way to go if one thinks there is a problem. And I take Steve's point that maybe one is naive to think there isn't, but I've certainly not come across the problems myself. But yes, I think rather advocacy than a market inquiry, which would perhaps be too resource intensive for us these days. And rather workshops.
Right. And Talita, it appears as if there's a trade-off between a less mobile workforce and higher employee or employer trust on the one hand, and more mobile workers, but lower employee-employer trust. Do you agree or do you disagree? And which one is best for the competitive process?
Now, why is she giving me this difficult question right at the
end? I'm glad she gave it to you first. Yeah, that's a tough one.
But I don't know that we need to choose. And I think there is a duty on employees to serve their employers in good faith while they are there, and then to comply with whatever post-employment restrictions there are. And I don't think that we are saying, well, either we will have mobile employees, but now we are not going to trust. So, what's the consequence of that? Then we are not going to train. We are not going to expose our employees. So I don't think that is really the trade-off. I think it is the balancing of rights. It is making sure that what you agree with your employees are reasonable. And ultimately, what we want in South Africa is not mobility from, necessarily this employer to that employer or to that employer. We want people to progress, might be in different employers, but actually what we need is more people in employment. We need to create jobs. And that is the employment mobility that I think needs absolutely urgent attention. And if that priority is, given attention, I think, and that actually is not, something that the competition lawyers on their own or authorities on their own can do, or the labor lawyers or whoever. We now need to take hands across industries, across disciplines, across ministries, basic education, higher education. Everyone need to work together now so that we can have workers with skill who will be useful and employable and who will flourish in the workplace. But I think that needs to be our focus.
Oh, that's brilliant. Thank you so much, Talita. I'm very mindful of time, and we are actually over time. So as Talita started, I think I'll say it's a very good place to end. I really appreciate all your wonderful, wonderful contributions to this topic. It's something that we have not yet really delved in Africa. So thank you so much for that. I really appreciate that. And I'm sure our attendees will also give you a big round of applause.